A judge in Cincinnati has declared a mistrial in the case of a white former police officer accused of killing an unarmed black man. The jury failed to reach a unanimous decision on whether Ray Tensing should be convicted of murder, voluntary manslaughter, or be acquitted. He's charged with shooting Sam DuBose in July of 2015 during a traffic stop. That confrontation was recorded on Tensing's body camera. The Hamilton County District Attorney spoke with reporters earlier today.
We're going to find out what happened, and the good news is, at least for the family in the state of Ohio, it was not a not guilty verdict, and we just got to make an assessment as to whether or not we can win a trial. We've heard that they were leaning towards acquittal on the murder, leaning towards conviction on the voluntary manslaughter.
I'm joined now on the phone by former federal prosecutor Doug Burns. Doug, did the prosecution reach too far in this case? Would they have been better off pursuing manslaughter and leaving murder completely off the table?
Yeah, that's an excellent question. I mean, a lot of times you make that decision as a prosecutor, put a little different spin on it. At least they didn't, go all in for murder only, as prosecutors did in the famous Casey Anthony trial, which really backfired on him. And there was a big confusion about what's called lesser included offenses. In other words, could the jury find a lesser one even though it wasn't charged? But here, back to your question, they charged both murder and voluntary manslaughter, and they may want to turn around and consider exactly the way you said, Rena, just charge, go forward for the second trial, voluntary manslaughter. You heard the prosecutor say, and it's important for everybody to understand, because sometimes there's some confusion. People say, well, wait a minute, why can you be tried again on a mistrial? That's not what we lawyers call double jeopardy, and you can go forward to a second trial. But the prosecutors might want to really seriously consider paring it down to voluntary manslaughter only.
So if there is a new trial, would you expect prosecutors to lower the charges, maybe to involuntary manslaughter?
Yeah, I do, actually. But at the same time, it's interesting because, we trial lawyers read tea leaves. And I was looking a little bit about, what the indications were as to what the jury was thinking. And apparently, at least my tea leaf reading of it, Rena, is that they were sort of focusing more on the voluntary manslaughter. That's why you heard the prosecutor say, we're going to find out a little more about what happened. Let me translate that as well. Jurors actually are free to speak. I saw what the judge had said to the jury on a video, and, she kind of cautioned them, you may not want to, go overboard with it, but, we trial lawyers speak to jurors and they're free to speak. So you get an indication as to sort of where they stand. The other point I would make real quick is that there was an interesting back and forth with what we lawyers call an Allen charge. In other words, the jury had indicated initially that they were having trouble, and the judge reads this charge that defense lawyers hate because they think it's a little coercive, which is you really should continue on. This is an important case. There's no reason to think that another jury would do any better than you, that type of thing. But notwithstanding the Allen charge, the jury came back and said, no matter what, we can't reach it. And then the judge declared a mistrial. And I've been through that exact situation many, many times myself.
Doug, there's also been some criticism about the makeup of the jurors. There were no black men on this jury. What's your take on that? How did that impact the trial?
Yeah, no, that's interesting. I mean, apparently, there's some racial component to the case, just by virtue of, the way it sets up and so forth. I'm not familiar, to be clear, with the voir dire, the jury selection process in this particular case and what took place. You're raising something interesting, though. There's a body of law that talks about, systematically excluding particular jurors. I'm not suggesting that's the case because, again, I have not seen anything about what took place. I've been in some dust-ups like that myself, picking juries both as a federal prosecutor and as a defense lawyer. But, again, I don't think that was necessarily all that dispositive. I mean, on the merits of the case, basically, what you had, is a highly disputed factual situation, prosecutors contending that he just flat out intentionally killed the person. The difference, by the way, murder is, the intentionally killing the person, with malice aforethought, call it. The voluntary manslaughter is the same thing in Ohio, but out of anger or passion, what sometimes is referred to as heat of passion, before you've been able to cool down, that type of thing. But the video, interestingly enough, and this is why the family's upset, and I can definitely see their point of view, apparently refuted, to some fairly significant extent, the version that was being offered by the defense. I mean, they were saying, consistent with the law of self-defense, that he was actually in fear of being run over. If that's the case in the academic classroom, then he's in fear for his life and can respond in kind with deadly force. But again, that was highly contested, apparently.
And the district attorney told reporters that if there is a retrial, this case could cost taxpayers more than $1 million. How does that impact their decision to potentially retrial or push for a plea deal?
No, that is an important factor, of course, particularly in light of, some of the things we went through in the presidential cycle about prosecutorial discretion and all of that. And I'm not citing the Clinton matter, but I'm just saying prosecutors all the time on a retrial, more than anything. I remember one time a case, I wasn't involved. I was sitting there waiting for my case. And the government had 2 hung juries in federal court. And Judge Corman, I have no hesitancy in using his name, Edward Corman, a legendary federal judge in the Eastern District of New York, looked at the prosecutors and said, do not bring this back here again, guys. And interestingly enough, he does not have the authority to tell them that. That's their decision. But the point is, back to your observation, prosecutors will weigh, look, what's the likelihood of prevailing on this? And as you said, Rena, you're right. What's the cost to the taxpayers, and how does that translate into justice? If I had to guess, I'll go to the sort of crystal ball. I think they will retry this case. I think it was a fairly close case. But they would be wise to go to school right on you, Rena. Pare it down to manslaughter.
Okay, and let's talk about the defense, though. How does a mistrial impact their argument going forward?
Yeah, no, that's a great question, and I'll tell you why. There's a split of authority among lawyers, trial lawyers. Who does a retrial help? And it's funny because I've seen some lawyers say, oh, it definitely helps the prosecutors because they can fine-tune, what they may have done wrong. They can pare down their approach. They can focus on what's important, and that's all true. And I've tried retrials as a prosecutor myself. I had the luxury of being on both sides. The counter-argument is, well, wait a minute. Now, the defense has seen the prosecutor's playbook, has time to focus on and think about, what they should focus on refuting. So it's a very, very interesting debate. Most retrials, interestingly enough, go a little bit quicker, are a little more pared down, because a trial for the first time is sort of like a dress rehearsal. Nobody's done it before. So you've gone through the whole trial. You have the record. You can look at it. So they generally go a little bit quicker. I wanted to focus one other thing you had said about a plea deal. Very important. In retrial situations, very often you'll see some kind of plea deal cut because the defendant, remember, doesn't know what it's like to go through a trial either, and it's a brutally difficult process. So they may turn around and say, well, all right, if we can get some palatable disposition on a manslaughter, plea, then maybe we'll just all cut our losses. So I think that's a distinct possibility as well.
Former federal prosecutor Doug Burns. Thank you, Doug.
My pleasure.